And welcome to our online video update. And in today's update, we're going to be talking about consular services availability and really get into some details about visa appointments at U.S. consular posts throughout the world and talk about some ways to get around some of the presidential proclamations. My name is Avi Friedman. I'm a partner with Wolfstorf Rosenthal. And as you can see, we have offices throughout the United States. Boston, our main office is in Los Angeles. We've got 2 offices there. New York, Oakland, San Francisco, and our international office in Shanghai, China. Some legal disclaimer to start off things. Please note that the information that we are presenting today does not constitute legal advice and is for informational purposes only. If you seek to obtain legal advice or opinions, then you would need to schedule a consultation with me or one of the other attorneys in our office. Real briefly, to talk about our firm, Wolfstorf Rosenthal is a full-service U.S. and global immigration law firm with a deep focus on the latest in technology. As mentioned, we have offices throughout the United States, as well as our international office in Shanghai. And we're very well known for providing exceptional, efficient, client-focused, immigration-based services. As you can see, we have various awards that our firm has won with cutting-edge scholarship presentations across various forums and holding prestigious leadership roles in the various immigration associations and memberships. Real briefly about myself, I've been with the firm for over 20 years. I have traveled extensively both to Mexico, Canada, and throughout the world to assist clients with visa applications and have helped hundreds of visa applicants, if not over 1,000, in person to represent them at various U.S. consular posts. Some of my experience as well, I've served on the American Immigration Lawyers Association, or AILA, the Department of State Liaison Committee for 7 terms over the years. Also had the honor of serving as the chapter liaison to the U.S. Embassy in Ottawa a few years back. And I also served many years as the Consular Affairs Liaison for the Southern California chapter of AILA. You have my contact information, avi@wolfstorf.com, and feel free to reach out if you have questions regarding consular or other U.S. immigration matters. So to get into our topic of today, I wanted to give a brief overview about the state of consular services availability. And so what most visa applicants are finding is that many, if not most, of the U.S. consular posts have been closed for quite a while for routine visa services due to the COVID pandemic. And so from the Department of State's perspective, they really have reduced staffing at the various U.S. consulates and embassies throughout the world. And so they just don't have capacity at this time to handle the demand for U.S. visa applications, both non-immigrant and immigrant. And so what that creates is an increased wait times because there's substantial backlogs to get visa appointments. And so the typical ways that one schedules a visa appointment is to go online and try to find a visa appointment. And what you're finding is that you try and schedule and you're pulling up the consular calendar of visa appointments and nothing is available. So it's very important just to keep checking, refreshing, because there's really no prediction in terms of when a consular post will release its visa appointment. So if you're constantly monitoring the appointment calendar, you may be able to find an appointment. But what you're finding when you're able to schedule a visa appointment at many of the U.S. consular posts is that they're only granting visa appointments for many months in the future. So you might only be able to find something, for instance, in April of next year, if you find an appointment, if you're lucky to be able to schedule. So there is an option at all U.S. consular posts to request an expedite. So this first requires that you lock in the earliest available appointment. So you got to schedule an appointment, and then you can request an expedite online, and there will be a screen online to explain what are your reasons for the emergency travel. And the next step is a consular officer in the non-immigrant visa unit will review that request and respond by email. And it's either going to be, we've granted you an expedite and this is the day that you can apply, or they will deny the expedite. An expedite request in general is going to be approved when there are humanitarian needs for travel, such as somebody seeking critical medical treatment in the United States. Some consular posts are more amenable to granting visa expedites for those that require urgent business travel to the United States. So if you can demonstrate the economic benefit to the US recovery, then you might be able to convince a consular officer to grant an expedite. If you're a student, F1, or an exchange visitor, and you're within 60 days of the start date of your program, you might be able to get an expedite depending on the post. And keep in mind that the expedite request, if granted, relates only to the scheduling of your visa interview. So that's to get your foot in the door and be interviewed by the consular officer. It doesn't necessarily mean that they will expedite the visa process, meaning the issuance of the visa and the return of your passport. So getting into one of the main topics for today's update is back in June, on June 22nd, President Trump signed Presidential Proclamation 10052, which extended a prior proclamation that had suspended entry to the United States of certain immigrant visa applicants through the end of this year, December 31 of 2020. This proclamation, passed in June, added the suspension of entry to the United States of H-1B, H-2B, and L-1 visa applicants, as well as certain J-1 visa applicants, interns, trainees, teachers, camp counselors, au pairs, summer work travel programs, and as well as spouses or children, so basically dependents, that were applying for the dependent category, so H-4s, L-2s, and J-2s. One of the key exceptions was that this proclamation did not apply to those who were in the United States on the effective date of the presidential proclamation, or who had a valid visa in one of those classifications that we discussed and were going to enter the United States on that visa. If somebody was not subject to this proclamation, then their spouse or children, their dependents, should not be prevented from obtaining a visa due to that proclamation. Now, to get around that presidential proclamation, Department of State created and announced this national interest exception, or N.I.E. for short. And so we're going to cover a few of these exceptions. One is if you're applying for your visa to resume, your H-1B visa to resume ongoing employment in the United States in the same exact position with the same employer and visa classification, basically an extension of your H-1B, and you're applying for your visa, then that is one of the exceptions. Or you can apply for your H-1B under the national interest exception if you can qualify under at least two of the following criteria. This would be the employer has a continued need for the H-1B services, and that there was an LCA approved by Department of Labor during or after July of 2020. So basically, if the LCA was obtained before July of 2020, then the visa applicant demonstrates the employer's continued need for their employment. And so this is if you're currently performing or able to perform the essential functions of your H-1B. If you're able to perform these functions from outside the United States, then you will not meet this criteria. Also, if the employer is meeting a critical infrastructure need and the visa applicant's job duties or position within the sponsoring company provides significant and unique contributions to the employer, you might be able to qualify under one of those prongs. And so what they mean from Department of State's perspective for critical infrastructure sectors, they listed financial services, IT, communications, healthcare, public health, transportation, chemical, defense, water systems, and nuclear reactors. Also, to meet this particular criteria, the visa applicant has to show that they hold a senior level placement within the sponsoring organization or have job duties which reflect performance of functions that are both unique and vital to the management and success of that overall business enterprise. Or the other way is to demonstrate that the visa applicant's proposed job duties and specialized qualifications show that they will provide significant and unique contributions to the U.S. employer. Another way is to show based on wages. So if the wage rate that you'll be paid as the H-1B visa applicant exceeds the prevailing wage rate by at least 15%, if you can show your education, training, experience, demonstrate unusual expertise in the specialty occupation in which you'll be employed. So for instance, you hold a high-level degree such as a PhD or MBA, and it's related to your job, or you have many years of experience in the field, that may be a way to qualify. The other route would be to show the denial of your visa application would cause financial hardship to your U.S. employer. So if the company would not be able to meet their financial or contractual obligations, or they would not be able to continue their business, or it would be an impediment to the employer's ability to return to pre-COVID level of operations, then you may qualify for under this prong. So in terms of how this national interest exception works is you would have to present documentation to the consular officer at the time of the visa interview, and they will review the documentation and your situation based on the documents and your responses to their questions at the interview. This is not adjudicated any time in advance of the visa interview, and it's done right there on the spot, or the consular officer would get back after they have completed their review. Now, there were lawsuits against the various presidential proclamations, and in one of the lawsuits on October 1st of 2020, the U.S. District Court for the Northern District of California issued a preliminary injunction which blocked the enforcement of this proclamation. Keep in mind, this injunction was limited to plaintiffs in the case, and so the plaintiffs included the National Association of Manufacturers, or NAM, Chamber of Commerce of the United States, and the National Retail Federation, TechNet, and Intrax. So any J1, H1B, H2B, or L1 visa applicant who is either sponsored by or petitioned by one of those plaintiffs or they're a member of one of those chambers or associations is no longer subject, while this injunction is in force, to those restrictions that we just talked about. It means that they can apply for their visas. The key is those visa applicants must be prepared to demonstrate that their employer is a named plaintiff or member of any of the named plaintiff associations. So you have to be able to prove that you would qualify. So how do you do that? Well, again, at the time of the visa interview, you would be providing evidence directly to the consular officer. And so some of the organizations are issuing letters to confirm that they are indeed a member in good standing, and so that they would qualify as one of the named plaintiffs. And then in addition to that, consular officers will take their own steps to independently verify that the sponsoring employer or petitioner is in fact a member of the plaintiff associations. And then if they are able to confirm that, the membership, then they can go ahead and continue to process the visa application and get around that presidential proclamation. So one of the things to consider is if your employer is not yet a member of the U.S. Chamber of Commerce, it's fairly straightforward and easy to apply, and you can see the link uschamber.com/members/join-chamber. So you can see the requirements online, and there's a small fee to apply, but you can actually now apply after the fact. So as long as the company is a member of the U.S. Chamber of Commerce, then you can get around this presidential proclamation. Now, what we have been seeing, though, from the Department of State's perspective is that even though there is this workaround to the presidential proclamation because of the limited visa appointment availability at most posts throughout the world, we're just not seeing visa appointments. So Department of State has a way to avoid issuing these H and L and J visas under the guise of they just don't have the visa capacity, they don't have appointment availability, and their staffing levels are reduced. So there still can be a hold in terms of being able to get your foot in the door and get an interview if you don't qualify for one of those expedites. So on this slide, you could find all our contact information for our various offices throughout the United States and in China. You have my contact information. Very easy to email me at avi@wolfstorff.com. Feel free to reach out. If you have any questions regarding today's update or any other questions regarding U.S. immigration matters, I do encourage everyone to go onto our website, wolfstorff.com, and sign up to receive our newsletters. We send out, whenever there's breaking news in the world of immigration, we do send out updates. So once you've signed up, you should be receiving those and you can keep up to date on all the latest in U.S. and global immigration. Thank you all for attending today's online video update.